Hi, my name is Charles Vethan. This is part of the Vethan Law Firm PC's video educational series. Today's topic focuses on the Texas Uniform Trade Secrets Act, or TUTSA. This is a new law that Texas passed in 2013 and is being explored by businesses and lawyers alike. Today's topic focuses on what constitutes a trade secret, what businesses can do to protect what they've developed as a trade secret, and third and most important, what they can do to prevent the theft or misappropriation of what they've developed to give them a competitive edge in the marketplace. For more questions, contact us at www.vethanlaw.com.
Our topic today is trade secrets and what are trade secrets. Joe, when everyone thinks of a trade secret, they think of the Coca-Cola special secret recipe locked in a vault somewhere. They think of the 7 herbs and spices of KFC. But the truth of the matter is that most companies have something that might be a trade secret if it was just treated right. What are some examples of a trade secret?
Well, Seth, trade secrets can be literally just about anything. Chemicals and manufacturing methods to make fertilizer, customer lists, vendor lists, source and object code for data processing, telecommunications architecture. All of these are the types of processes and information that Texas courts have traditionally found to be eligible for trade secret protection. But in order to be a trade secret, 2 important requirements have to be met. First of all, under Texas's new Uniform Trade Secrets Act, the information or process has to be, the trade secret has to be, have independent economic value that comes from it not generally being known to others or easily learned by others. And second of all, it has to be the subject of reasonable efforts to keep it secret.
So Joe, what you're saying is that we have to keep it a secret. Well, what are some steps that an employer can take in order to keep a trade secret secret?
Well, the steps will depend upon the nature of the business. Common steps for secrecy include non-disclosure and confidentiality agreements with key employees who have access to it, limiting access to the trade secret of the information. If it's documents, marking it confidential or secret. If it's an electronic file, password protecting the file and providing limited access, storing it in a vault or a locked drawer. All are examples of different methods courts have concluded amount to keeping the information or process a secret.
And I think the key to remember is that it needs to be reasonable efforts. So we don't need a Coca-Cola vault, but you need to take reasonable efforts to limit it to who's seeing it, who has access to the secret, and making sure that it actually gives value to your company. Now, Joe, the other question we get a lot when it comes to trade secrets is what's the difference with a patent and why choose a trade secret over patenting something?
Well, patent has a shelf life. A patent lasts for 20 years. At the end of 20 years, anyone is free to use the patented invention. With a trade secret, the potential for the secrecy and the exclusion of the general public from using it is indefinite. It could last 20 years, 30 years, 40 years, 50 years. Coca-Cola is a perfect example of that, something that's been kept secret for many, many years. So long as the secret's not publicly disclosed in such a way that destroys the secrecy protection under the law, then you retain your interest and ability to exclude the public from its general use.
It is important that companies identify the information and processes that give them the competitive edge in their industry and take the steps necessary to protect that information from disclosure. For more information, visit us at vethanlaw.com.